A lot of schools will say, oh, we give our students, if they're named as a respondent, if you've been accused of doing something wrong, you're a respondent, a support person. Well, guess what? That person is typically a student volunteering or an administrator paid by the school, and they're not really that invested in making sure your kid's protected.
Nor do they understand your students' disabilities, because the minute they're charged, we know there's a lot more emotion, a lot more anxiety. So when we're lucky enough to get those clients, the first thing Christina and I do is make sure that not only do they have us, but they enlist the help of a mental health professional.
Have the right supports. And I think a very common misunderstanding is, this is America, innocent until proven guilty. Title IX cases are not criminal cases. Often there can be both operating at the same time. However, in a Title IX case, a student cannot rest on the presumption of innocence. Student has to take a more active role in the investigation. But I want to be really clear. A student who is named as a respondent should never speak to an investigator without having a support person with him or her. And so when Susan and I handle these cases, although we're lawyers, our title is actually advisor or support person. And it's really important that we're there to guide and shape the conversation. Because as we all know, these conversations often don't go well, particularly if the investigator doesn't understand that you have a student on the spectrum.
One of the things that we do is we recognize that the process is guided by a school's policy and by a lot of outside federal law, and that it's really, really, really confusing. So we work really hard to meet with the family and the students and to break down what's going to happen in small chunks and try not to get ahead of ourselves and really say, okay, all we have to do right now is prepare for your interview. Let's not think about the hearing. The hearing may or may not happen.
So that point, the interview, a common challenge that we face is that a school will say, "Dear Mr. Smith, there's been a report made against you. Please come into my office so we can discuss." The report involves Susie. Mr. Smith goes because he's a nice boy. He follows the rules. It's an authority figure. You go, you sit, you have a discussion, but you don't actually know what you've been accused of doing. And so what we face a lot is this issue of sufficient notice of the conduct in question. So in other words, what did I actually do wrong? What is Susie saying I did that was so that caused Susie to feel harm? And this is something that I think most of us would take for granted, that you would actually be told what you're accused of doing. And unfortunately, no. It's boilerplate letters saying, "Come in, you violated our policy." And again, for a student on the spectrum to fill in the blanks there and to know who this person is, what day, where, what the situation might have been. I mean, as lawyers, it's challenging for us, let alone, again, someone who's new to this environment and overwhelmed and has a social communication disorder.